Hey guys, and welcome back to today's video. This time, we're heading to Colorado, where I came across a defendant who insists he is not a sovereign citizen, right before proceeding to make almost every sovereign citizen argument in the book. You know how this goes. Different label, same script, same outcome. And trust me, this one checks all the boxes. It's a good hearing, so do me a favor, hit that hype button down below, and let's get into it.
Are we ready for Mr. Shadowins?
Yes, Your Honor.
Come on up, Mr. Shadowins. And I know that the bondsperson also had mentioned that he wanted to address the court. But anyway, for the record, this is 25T448, 25M352, 25M395, 25M375, 25M318. All people v. Joseph Shadowins, who appears in person in the courtroom. Mr. McKissick from the District Attorney's Office appears in person as well. You're standing. So Mr. McKissick?
Yes, so I was able to speak with the defendant a little bit about kind of the 5 cases coming up. It doesn't appear that we'd be able to reach a resolution considering some of the things that I would have pointed to as direction for the defendant doesn't seem like something that they would be willing or able to do. This would include picking up one of their issues that they haven't been given any discovery on any of these cases. I let the defendant know that I myself do not give or take in discovery. That's something that can be asked for from the district attorney's office by going there physically and then asking for the discovery, which would be handed over at that time. The defendant let me know that that would not be possible for them, that he was told that if he were to go to the district attorney's office that he would be arrested. It's not typically something that the district attorney's office would impose a arrest for someone coming to pick up discovery without some other maybe factors that haven't been mentioned. So I'm kind of at an impasse as to what to do. It seems like many of the asks by the defendant is not something that I can readily take care of, even though that would be a simple solution, is just going down to the DA's office and getting up discovery. But moreover, he's asked me to take some of his own evidence, which is not something that I was willing to take at this time. I think from a procedural posture in this case, we're once again at an impasse. I think the defendant claims that they're not a sovereign citizen, even though many of their arguments align fully in place with some of the arguments that I've seen from sovereign citizens. He's asking for a change of venue to a basically a court that we don't have in the state, common law court. So like I explained to them, this precedent that they're brought up is kind of their argument, or perhaps their defense. It's not a valid argument, and there's nothing that I can do as a prosecutor to have the case moved to a court that doesn't exist, essentially. So I'm not exactly sure what to do.
Well, if you really want to find them, you can start by heading down to your local Waffle House, where they apparently hold their weekly sovereign citizen common law courts. But before we get back to today's nonsense, let's talk about today's sponsor, Extra. Extra is genuinely one of my favorite brands to work with, and not just because they make clean, stylish products. I've personally been using my Extra wallet for over 3 years, and it's been with me everywhere. With Christmas right around the corner, this is honestly one of the easiest gift recommendations I can make. Their wallets hold more than enough cards for the average person and feature a quick release button that lets me access my cards instantly. I don't even have to pull my hotel key out, I just press the button, and the cards slide right out. That means my ID, credit cards, and room key are always together and easy to grab. Since partnering with Extra, they've also expanded into new products, like these vacuum travel bags, which are an absolute game changer. I'm actually heading back to Texas in a few days, so let me show you how this works. You load the bags with clothes, attach the USB-C rechargeable vacuum pump, and watch the bag compress down to a fraction of its size. I can fit weeks' worth of clothes into a carry-on and still have room left over for Christmas gifts. Head over to partneredextensioner.com/teamcoepic, save up to 54%, and use code SKEPTIC at checkout for an extra 10% off their already discounted holiday prices. Huge thanks to Exeter for sponsoring today's video now. Let's get back to this sovereign citizen who definitely isn't a sovereign citizen while he makes every sovereign citizen argument imaginable.
Okay, Mr. Shadowins.
Thank you, sir. I'm here by special appearance this morning.
Mm-hmm.
So I am not, on and for the record, a sovereign citizen, nor have I ever been a sovereign citizen, though I agree with the state's position that many of the claims and statements I make are in alignment with that. I have clearly corrected my status as de jure on and for Teller County records that this court has admitted they haven't read. I have filed motions to dismiss many of these cases based on those records and the subsequent motion to dismiss. Your Honor admits on record she has not read and denied. So I am not aware of any victim. The evidence I was trying to give the state this morning with respect to an alleged victim are rebuttals to affiance. So I do not qualify for an attorney. I cannot afford an attorney due to damages from the state, nor can the state provide a common law a defense with the assumption that I am a domestic terrorist. That is a clear conflict of interest. Your Honor herself has admitted multiple times on record in multiple cases, calling me a sovereign citizen, refusing to answer my questions, dismissing them as sovereignty arguments, and so on and so forth. This is clearly due process issues, clearly conflict of interest issues, and I cannot plea or proceed without full discovery of facts, evidence, and elements. There are also issues on the docket today that Miss Hudgens' name is under. I have never consented to an attorney. I have no discovery. I have no complaints. I have not even basic discovery. So how can I defend myself if I can't speedily rebut claims?
Okay, so thank you, Mr. Shadowins. So what I'm hearing is there's an issue about discovery. You know the process to get the discovery, which is to go to their office in Colorado Springs. They have a discovery, apparently some kind of office, and you can obtain all the discovery in these cases. If you hire an attorney, that attorney could also go and request that discovery. And what's the problem with that, sir?
I have receipts. I have emails from DA's office saying, "Do not come here. We will arrest you."
Where are they, sir?
I wasn't prepared to make that argument. I tried to give evidence of rebutting of affidavits today. Prosecution won't take it. Non-response from the DA's office times 2 prosecutors.
Stop. Let's
You-
stop.
allow
I'm
me to
trying
speak,
to
please.
get, I'm trying
Please
to
do not
get,
rush justice.
can we get
I'm
an
trying to answer your
answer?
question.
Well, I hear that you're saying that you don't have anything
I don't have it
from.
with me today,
Okay.
but I have emails to multiple prosecutors plus Ms. Schaaf, senior investigator, requesting discovery disclosure of evidence. I was told I could go to the police station to pick it up, denying the fact that I have restraining orders from multiple police officers for whistleblowing. Okay, I can't go to pick it up in person because cops took my truck. That was the principal issue leading to all of these cases, a driving versus traveling issue deemed sovereign citizen arguments. I have never been a sovereign citizen. I have common law standing on file with the county, and I cannot get a common law court. So at this point, I don't know how to proceed without evidence. I can't plead without evidence other than non-assumpsit by way of confession and avoidance and invoke my right to subrogation.
So we've got an extra special appearance of someone trying to change his legal status. No victim, common law standing in a so-called common law court, not consenting, driving versus traveling, and one I haven't heard in forever. Subrogation. If you're looking for a way to tell everyone you're a sovereign citizen without actually saying the words, congratulations though, wait. You just did.
You know, the problem, Mr. Shadowins, as you say that you are not a sovereign citizen, but as I would agree with Mr. McKissick, your arguments are in alignment with arguments that sovereign citizens make.
Which is a
So what
conflict
I'd
of
like
interest.
what I would like to say, I'm not making the argument, it's you
You
are.
called me a sovereign citizen yourself, Judge.
So I would say at this point, Mr. Shadowins, that your arguments do align with sovereign citizen arguments.
Object, personal opinion bias.
I get you. It looks like you have someone here who perhaps could take you to the district attorney's office in Colorado Springs, although I know because of your past failures to appear, he's had to post bonds, and I think he had some questions about that.
Yes, do I have clearance to not be arrested if I go and try to petition for discovery? I do not wish to motion for discovery with jurisdiction issues raised by the state not affording me the opportunity to rebut. The state twice raised the issue of jurisdiction, and I was not afforded a rebuttal. These affidavits clearly rebutted, and there's no notary present in the court today. Mr. Kissick will not allow me to submit evidence in my defense.
So, the thing also, Mr. Shadowins, is it's very confusing to follow your arguments.
That's because I'm common law and you don't recognize that, which is the bias and conflict of interest.
That is absurd. That is an absurd argument, Mr. Shadowins, and I will not.
Objection, personal opinion.
Thank you. I have made my ruling. It's absurd. So here's what I would, I did, and I will say that I did read the documents that you did file, Mr. Shadowins. Even though your handwriting is not easy for me, I had to, you filed, the last thing that you filed, your motion to dismiss, was filed on the day of your last court appearance, and I did not have the time to look at that beforehand.
Motion to reconsider.
Okay. That makes no sense. Haven't ruled. You only asked to reconsider if I've already ruled.
You dismissed my motion.
I have not,
You dismissed my motion to dismiss based saying that you hadn't read it. I take no adversarial position.
That's because you're the defendant. The only adversarial position you're taking today is against yourself, with a bunch of sniffable glue sticks in your pocket. Now, this judge is usually very patient, but this __ is about to push her limits, and she's about to do the unthinkable, raise her voice at him.
Mr. Shadowins, the reason that I told you I hadn't read it is because it would take me some time to go through it.
Understood.
So I'm not, I did not rule on your motion at the last hearing. In regard to due process of law, I went through your motion for dismissal, Mr. Shadowins, and in regard to due process of law, there's really no clarity about what specifically you're concerned about, but you have, as far as due process rights to be heard and to, let's see, to understand, to be heard and to have it says no one shall be condemned without an opportunity to be heard. So you have had the opportunity to be heard. You've appeared in court. There is no violation of due process of law. In regard to the Sixth Amendment, also I will find, as far as due process of law, if your concern is about the statute, the court is, there's nothing specifically about any of the statutes of which you're alleged to have violated, you've not said, they're not sufficiently clear to persons of ordinary intelligence to afford a practical guide for law-abiding behavior and capable of even-handed enforcement. All the statutes in these cases that have been charged as violations against you, court does find that they are sufficiently clear to persons of ordinary intelligence, and they are capable of even-handed enforcement.
I don't even know what that means, Your Honor.
Wait,
I'm
I'm responding to you raise these issues. You write due process of law with no real explanation. I have to make assumptions about what that means.
Objection, the court would not hear it.
In Sixth Amendment,
Dismissing it as sovereignty arguments, end quote.
I have not dismissed. I am ruling right now,
You
Mr.
can't rule. You haven't heard the
Mr.
matter.
Shadowins. I did read your motion and I am ruling right now, so be quiet. In regard to the Sixth Amendment, that the Sixth Amendment provides for speedy public trial by an impartial jury, informed that you be informed of the nature and cause of your accusations, that you are confronted by witnesses against you, have a right to subpoena witnesses and right to counsel. You have all of those rights. None have been denied to you. In regard to obstruction of justice, there's no, the court denies that or dismisses that argument. There's no specifics. It just simply says obstruction of justice. Prosecutors refusing to respond with discovery, court denies that. Court notes that the district attorney has provided information how Mr. Shadowins can obtain that discovery. In regard to state can't be an injured party, the state does file the cases to enforce public laws and publish violators. The primary goal of the state is to ensure justice for the community, not just a specific individual's loss. So that is, so I deny your
Point of clarity,
dismiss.
please. Objection, point of clarity.
No, sir, I am ruling. It's my opportunity to talk.
You're not hearing me.
You can write down what you.
I did write it down. You're not reading the complete statements.
No, sir.
You're not reading the complete, I'd like to read the records for the record.
It's always wild to watch a veteran with service-connected disabilities go from being a respected member of society to a certified Looney Tune with domestic terrorism aspirations. But he steps aside, and now we get to hear from the absolute idiot who bonded him out.
No, I don't. No, you're not going to be reading
Let
that.
the record show the court.
You can always file that, Mr. Shadow.
I did. I did. It's on file.
All right. I have ruled that, that nothing about the state, the fact that all your cases are the state of Colorado versus you does not prevent those cases from proceeding forward. Those cases will continue. In regard to change of venue, there's no reason under Rule 21A of the Colorado Rules of Criminal Procedure to find that you would not be able to obtain a fair or expeditious trial in Teller County. So I deny that request at this time. If you wish to submit some additional information about why you think there should be a change of venue under Rule 21, you should follow the rules there.
I do. It's right here. I'd
Irrevocable,
like to read it for the record.
Irrevocable trust is an absurd argument. Traveling, not driving. I did rule on the record in this on that issue before. In People v. Zen, the right to drive a car on public roads is not a fundamental right. States do have the right to regulate the use of motor vehicles on roads in this state.
Revoke the claim of a contract of a valid driver's license.
So that argument regarding traveling, not driving is denied. Impossibility to obtain your driver's license. I have no authority over the Department of Motor Vehicles. That's something you will have to deal with the Department of Motor Vehicles about. You have been in this courtroom all morning and heard different people talk about their efforts to obtain their driver's license. You can certainly get that information from the Department of Motor Vehicles. In regard to WebEx authorization, you are authorized to appear by WebEx, and you have appeared by WebEx on the last court date. Again, you raise the same issue regarding discovery. I have already advised you that how you get that discovery. All I can do is say, well, if the clerks did not get message regarding your request to appear by WebEx, and that's why you had a failure to appear, we do the best we can. We're not perfect, but we do try and get information to you as quickly as possible. Again, you have no injured party, the victim listed as the state of Colorado. Again, that is not the state of Colorado. Represented by the district attorney's office is representing the rights of the public
And the judge and the judge and the...
to enforce the laws. No, Anyway, I rule, you can interrupt and try and prevent me from saying
You're
things.
not
Mr.
reading the
Shadow.
complete record, ma'am.
I am reading it and.
I
ruling.
object.
I understand you object and that's
I heard
fine.
my objection.
No, as far as a valid warrant, you actually did have valid warrants in 25M375, 25M352, and 25M318. You also had summonses in 25T448 and 25M395, which are authorized under Rule 4.1 of the Rules of Criminal Procedure. So I have ruled on your motion to dismiss and it is denied. All right?
May I approach the bench?
Why? Why?
Evidence.
I don't need your evidence at this time. Evidence is generally something you present at trial. So,
Understood. Thank
That's
you
fine.
for the point of clarity. I'm going to allow this gentleman to address bond.
one second,
I'm going to plead non-assumptive.
but
Okay?
that isn't a plea, but I can enter a,
Not
I can
guilty.
enter a guilty plea for,
Not guilty.
not guilty, sure.
Not guilty.
I can enter not guilty
And
pleas
please
for you.
appoint
But
assistance of
first-
counsel.
I know he's been standing mute this whole time, but staying silent while the judge is about to question your competency is probably the worst possible move. Unless, of course, your goal is to get admitted to a psych ward until they decide you're competent and the trial can move forward. In other words, you might actually want to participate, because there's no easy way out here.
No, hold on. I need to go through some questions with you. I have to give you the Arguello advisement because.
Sorry, the what?
It's called the Arguello advisement. It's based on a case 772P2 87. I have to ask these questions of you since we are setting all your cases for trial and you have no attorney. Do you understand that anything you say can be used against you?
Yes.
Do you understand you have the right to be represented by an attorney throughout these proceedings?
Yes.
Do you understand that if you cannot afford an attorney, one will be provided for you free of charge? You have to apply for the public defender and see if you're
I don't
eligible.
qualify.
Okay, all right. Do you understand I will appoint counsel if you want an attorney to represent you? Of course, you must be eligible financially for their assistance.
I'm not due to injury from the state.
All right. Do you understand the charges against you are
No.
multiple, Mr. Shadowens? You have failure to display proof in 25T448. There's failure to display proof of insurance, which is a class 1 traffic misdemeanor carrying possible penalties of 10 days to 1
Due
year.
to disability,
10 days to 1 year. in the
impossibility.
county jail, and or $500 to $1,000 fine. You're charged with driving under restraint, a Class A traffic infraction carrying a fine. You're also charged with having a fictitious registration plate, which carries 10 to 90 days in the county jail and or $150 to $300.
I have a rebuttal.
You also have a registration, unregistered vehicle, which I believe is a Class B. Give me a second. Traffic infraction, I believe. 48.
I have a rebuttal, Your Honor.
No.
I'd like to read a record on for the record, which reads, and I quote,
I am doing the Arguello advisement, Mr. Shadowins, which means I have to go through all your
I don't
charges.
have an attorney.
in 5
I don't have an
cases.
attorney. I
I
can't
know,
defend
and
myself
that's-
on 5 cases with no evidence.
That's
I
what-
would just like to read a record
No.
and get an
Not-
attorney.
Not.
Can we set the matter over when I speak to counsel, please? I have disabilities.
Are
I'm
you going
really
to
overwhelmed.
hire counsel, Mr.
I can't
Shadowins?
hire counsel. The court said they would appoint an attorney. I don't apply. I don't qualify for a public defender. Even though the public defender is named on some of these cases, I've never spoken to, Your Honor.
We'll take them off. We'll make sure her name is off of that. But I am right now in the midst of the Arguello advisement. We're going to set your cases for trial. You're entering not guilties. We're setting your case for trial and pretrial readiness. To do that, I have to run through these questions with you.
Thank you for the
in
point of
order
clarity.
to-
Can I take a moment to recess, please?
Why?
Because I have service-connected disabilities to include PTSD and schizophrenia, and I'm extremely overwhelmed due to the nature of the adversarial nature of this proceeding.
Okay, go ahead, sir.
When would you like me back?
You 5 minutes. I'll give you 5 minutes.
To
5
address,
minutes.
to address bond, please.
5 minutes out there.